I knew something was wrong the moment I turned onto Lakeshore Drive and saw the gleaming chain-link fence blocking what had been an open path for the last 15 years. The metal gate stood there like a prison barrier, complete with a heavy-duty padlock that caught the morning sun and seemed to mock me. My fishing rod was in the back of my truck, my cooler was packed, and I had been looking forward to this Saturday morning on Lake Harmony since Tuesday. Now I was staring at an obstruction that had no business being there. My name is Trevor Brennan, and I had owned my property at 847 Lakeshore Drive in Cedar Springs, Michigan for 15 years. When I bought the place back in 2011, one of the main selling points was the deeded lake access. The previous owner, old Mr. Henderson, had shown me the original plat map from 1987 that clearly indicated a 20-foot wide easement running from the main road down to the lake. Every property owner on our side of the development had rights to use that path. It was not a suggestion or a courtesy. It was written into our property deeds, recorded at the county courthouse, and as legally binding as the property lines themselves. I parked my truck and walked up to the gate. A laminated sign hung from the chain link, and I felt my blood pressure rising as I read it. Private property, no trespassing. Violators will be prosecuted. By order of Lakeshore Estates HOA. There was a phone number at the bottom and the name Patricia Carmichael, HOA President, in bold letters. I pulled out my phone and took several pictures of the gate, the lock, and the sign. Then I called the number. It rang 4 times before a woman answered with a tone that suggested I had interrupted something terribly important. Lakeshore Estates HOA, Patricia speaking. Hi, this is Trevor Brennan at 847 Lakeshore Drive. I'm standing at the lake access path and there's a locked gate blocking it. I need to know what's going on. There was a pause, then a sigh that sounded rehearsed. Mr. Brennan, the gate was installed for security purposes. The lake access is now restricted to maintain the property values and safety of our community. Restricted how? I have a deeded easement to use that path. It's part of my property rights. The HOA board voted last month to implement new security measures. If you want access, you'll need to apply for a key card, pay the annual lake access fee of $500, and agree to the new usage restrictions. I felt my jaw tighten. I'm not part of your HOA. My property was here before the HOA even existed. And I'm certainly not paying for access to something I already have a legal right to use. Patricia's voice took on that particular edge that I would come to know very well over the following weeks. It was the sound of someone who believed that saying something with enough authority made it true. Mr. Brennan, everyone in Lakeshore Estates is subject to HOA rules. If you refuse to comply, you'll be in violation and we can place a lien on your property. Let me be very clear, I said, keeping my voice level despite the anger building inside me. My deed predates your HOA by 12 years. I never signed any HOA agreement, I never agreed to any covenants, and I'm not paying you a single cent for something I already own rights to. Remove this gate by tomorrow or you'll be hearing from my attorney. That's your choice, Mr. Brennan, but I assure you, the HOA has every legal right to manage common areas. Have a nice day. She hung up before I could respond. I stood there looking at the gate for another minute, then got back in my truck and drove home. My fishing trip was ruined, but that was the least of my concerns now. I had dealt with unreasonable people before, but this was different. This was someone actively trying to take away something I had paid for and owned. The moment I got home, I pulled out my property paperwork. I had kept everything organized in a file cabinet, including the original deed, the title insurance policy, the survey, and most importantly, the plat map showing the easement. I spread everything out on my dining room table and read through it carefully. The language was clear. Lot owners on the eastern section of Lakeshore Estates had perpetual access and easement rights to the designated path leading to Lake Harmony. The easement was 20 feet wide and ran from Lakeshore Drive to the water's edge. It could not be obstructed, modified, or restricted without the unanimous consent of all lot owners who held rights to it. I counted 12 properties that had the same easement rights I did. That meant Patricia and her HOA board would need permission from all 12 of us to legally block that path. I was absolutely certain they had not asked for mine. Monday morning, I called my attorney, Richard Kopecky. Richard and I went back about 10 years. He had handled the closing on my property, helped me with a contract dispute with a roofing company, and successfully defended me when a delivery driver claimed he had slipped on my driveway. Richard was in his early 60s, with gray hair and a methodical way of working through problems that I appreciated. Trevor, good to hear from you. What's going on? I explained the situation, telling him about the gate, the phone call with Patricia, and the HOA's demands for payment. Richard listened without interrupting, which was one of the things I liked about him. When I finished, he asked me to bring all my property documents to his office that afternoon. I showed up at 2 o'clock with my file folder. Richard's office was in downtown Cedar Springs, in one of those renovated brick buildings that had probably been a warehouse or factory back in the day. His secretary showed me into his office, where he was already reviewing something on his computer. "Trevor, sit down. I pulled the public records for your property after we talked. You're absolutely right about the easement. It's recorded with the county and it's clear as day. The HOA doesn't have the authority to restrict your access, so what do I do?" Richard leaned back in his chair. "First, I'm going to send a letter to Patricia Carmichael and the HOA board. It's going to explain very clearly that they're interfering with your property rights, and they need to remove the gate immediately. I'll cite the relevant statutes and case law. Most of the time, that's enough to make people back down, and if it's not enough, then we file for an injunction in circuit court. We ask a judge to order them to remove the gate and restore your access. Based on what I'm seeing here, I'd say we have a very strong case. What's this going to cost me?" Richard pulled out a legal pad and wrote down some numbers. The letter is straightforward. $500. If we have to go to court, we're looking at more. Filing fees, research time, court appearances. Probably $3,000 to $5,000 to get through an injunction hearing. If they fight it hard and it goes to a full trial, it could be more. But Trevor, here's the thing. If we win, and I think we will, we can ask the court to award you attorney's fees. That means they'd have to pay for your legal costs. I nodded. "Send the letter." Richard drafted it that afternoon, and I read it before he sent it out. It was 3 pages long and left no room for misinterpretation. It explained that I held a valid easement, that the HOA had no authority to restrict it, that their actions constituted unlawful interference with my property rights, and that they had 5 business days to remove the gate or face legal action. The letter was professional but firm, exactly what I needed. 4 days later, I got a response. It was not from Patricia Carmichael. It was from an attorney named Douglas Pemberton, representing the Lakeshore Estates HOA. The letter was condescending from the first sentence. It claimed that the HOA had broad authority to manage common areas, that the lake access path had been designated as a common area subject to HOA control, and that my easement rights did not override the HOA's authority to implement reasonable security measures. The letter concluded by stating that if I attempted to damage or remove the gate, I would be subject to criminal trespassing charges. I forwarded the letter to Richard. He called me an hour later. "This guy Pemberton is blowing smoke. His argument doesn't hold water. Your easement was recorded first. It's specific, and it grants you unrestricted access. The HOA can't just declare something a common area and override existing property rights. We're filing the injunction. How long will this take? Depends on the court's schedule. Could be a few weeks to get a hearing date. In the meantime, you're blocked from the lake. I know that's frustrating, but we're going to fix this." Richard filed the complaint the next day. I was listed as the plaintiff, and the Lakeshore Estates HOA was the defendant. The complaint laid out the facts, attached copies of my deed and the plat map, and asked the court for a preliminary injunction ordering the HOA to remove the gate immediately. It also asked for a permanent injunction preventing the HOA from interfering with my easement rights in the future, and it requested attorney's fees and costs. While we waited for a court date, I started talking to my neighbors. I wanted to know if anyone else was having problems with the HOA. It turned out I was not alone. I walked down to 823 Lakeshore Drive, where Mike Torres lived. Mike was about my age, maybe a couple of years younger. He worked as an electrician and had bought his place around the same time I bought mine. I found him in his driveway working on his boat motor. "Mike, you got a minute?" "Sure. What's up?" I told him about the gate and the lawsuit. Mike's expression went from curious to angry in about 10 seconds. "Are you kidding me? I've been trying to get down to the lake for 2 weeks. I thought maybe they were doing maintenance or something. I didn't realize they put up a gate. You have the same easement I do. It's on your deed." Mike wiped his hands on a rag and shook his head. "This is ridiculous. I paid for lake access. That's why I bought here. What are you doing about it? I've got an attorney. We're in court in a few weeks. You might want to join the lawsuit." "Hell yes, I want to join. Give me your attorney's number." I gave Mike Richards' contact information, and by the end of the week, 3 more property owners had joined the case. Richard amended the complaint to include them as plaintiffs, which strengthened our position. Now, it was not just me fighting the HOA. It was a group of us, all with the same easement rights, all being denied access to something we legally owned. The hearing was scheduled for late October. In the meantime, I tried to go about my normal life, but the situation gnawed at me. I drove past that gate every few days, and each time I saw it, I got angry all over again. It was not just about fishing. It was about principle. It was about someone thinking they could take away my rights just because they had a title and a board vote. About 3 weeks before the hearing, Patricia Carmichael showed up at my door. It was a Tuesday evening, just after 6. I was making dinner when the doorbell rang. I opened the door to find a woman in her late 40s with short blonde hair, expensive-looking glasses, and an outfit that screamed, "I need to speak to your manager." She had a leather portfolio under one arm and a smile that did not reach her eyes. "Mr. Brennan, I'm Patricia Carmichael. I thought it might be helpful if we talked in person." I kept my expression neutral. "What do you want to talk about? May I come in?" "No." "You can say whatever you need to say from there." Her smile faltered for a second, then came back. "I understand you're upset about the gate, but I think there's been a misunderstanding. The HOA is trying to improve the community for everyone. The lake access was being abused by people who don't even live here. We had problems with litter, noise, vandalism. The gate is for everyone's benefit. The gate is blocking my legal access to the lake. That's not a misunderstanding. That's a violation of my property rights." Patricia opened her portfolio and pulled out a sheet of paper. "We're prepared to offer you a complimentary key card for the first year. No charge. You just need to sign an agreement acknowledging the HOA's authority to manage the lake access. I'm not signing anything that gives your HOA authority over my property rights, and I'm not dropping the lawsuit. Mr. Brennan, this legal fight is expensive. It's costing the HOA money, and it's costing you money. Wouldn't it be easier to just work together? You know what would be easier? You could remove the gate and stop interfering with my easement. That would solve everything." Patricia's expression hardened. The fake friendliness evaporated. "You're being unreasonable. The other residents support the gate. You're in the minority here. I don't care if I'm the only person who objects. My rights aren't subject to a popularity vote. Now, if you'll excuse me, I have dinner cooking." I closed the door before she could respond. Through the window, I watched her walk back to her Mercedes SUV and drive away. I felt a small sense of satisfaction, but also a growing certainty that this fight was going to get worse before it got better. The hearing was set for October 27th in the Montcalm County Circuit Court. Richard prepared me for what to expect. It would be a preliminary hearing in front of Judge Margaret Sinclair. Both sides would present their arguments, and the judge would decide whether to grant the preliminary injunction. If we won, the HOA would have to remove the gate immediately while the case proceeded. If we lost, we'd have to wait for a full trial, which could take months. The day of the hearing arrived. I put on my best suit and drove to the courthouse in Stanton, about 20 minutes from Cedar Springs. Richard met me outside. He had a briefcase full of documents and a calm confidence that helped settle my nerves. "Remember, you probably won't have to say anything today. This is mostly legal arguments. Just stay calm and let me handle it." We went through security and found the courtroom. Patricia Carmichael was already there with Douglas Pemberton, her attorney. Pemberton was younger than I expected, maybe in his mid-30s, wearing an expensive suit and wire-rimmed glasses. He and Patricia were talking quietly at their table. Patricia saw me come in, and her expression was cold. Mike Torres and two of the other plaintiffs, Jennifer Loomis and Carl Daniels, were there as well. We all sat together behind Richard at the plaintiff's table. The courtroom was old but well-maintained, with dark wood paneling and high ceilings. A few other people were scattered in the gallery, probably waiting for other cases. At exactly 9 o'clock, the bailiff stood up. "All rise." The Montcalm County Circuit Court is now in session, the Honorable Margaret Sinclair presiding. Judge Sinclair came in from a side door. She was in her early 60s, with gray hair pulled back in a bun and a no-nonsense demeanor. She took her seat and looked at the papers in front of her. "Good morning. We're here on the matter of Brennan et al. Versus Lakeshore Estates HOA, case number 2026-2847. This is a hearing on the plaintiff's motion for preliminary injunction. Counsel, please state your appearances." Richard stood up. "Richard Kopecky for the plaintiffs, Your Honor." Pemberton stood. "Douglas Pemberton for the defendant HOA, Your Honor." "Thank you, Mr. Kopecky. This is your motion. Please proceed." Richard walked to the podium between the two tables. He spoke clearly and methodically, laying out the facts. He explained that we owned properties with deeded easement rights to the lake access path, that those easements were recorded and unambiguous, and that the HOA had erected a locked gate blocking our access. He cited Michigan property law and several cases that supported our position. He argued that we were suffering irreparable harm because we were being denied access to something we legally owned, and that money damages would not be adequate to compensate us. He asked the judge to order the immediate removal of the gate. Judge Sinclair listened carefully, occasionally making notes. When Richard finished, she turned to Pemberton. "Mr. Pemberton, your response?" Pemberton stood and approached the podium. His argument was more aggressive. He claimed that the easement was subject to reasonable regulation by the HOA, that the gate was a reasonable security measure, and that we were not being denied access, merely asked to follow reasonable procedures. He argued that the HOA had authority under Michigan law to manage common areas, and that the lake access path was a common area. Richard had warned me that Pemberton would make these arguments and that they were legally weak. I watched Judge Sinclair's face, trying to read her reaction, but she gave nothing away. When Pemberton finished, Judge Sinclair asked some questions. She wanted to know when the easement was created, when the HOA was formed, whether we had ever agreed to be part of the HOA, and whether the easement language contained any restrictions. Richard answered each question with references to the documents he had submitted. Pemberton tried to interject a few times, but the judge kept her focus on Richard. Finally, Judge Sinclair sat back in her chair. "Mr. Pemberton, I've reviewed the easement language. It grants the plaintiffs perpetual, unrestricted access to the lake via the designated path. I don't see any provision that allows for regulation or restriction by a homeowners association. How do you respond to that?" Pemberton cleared his throat. "Your Honor, the easement must be interpreted in the context of the broader community. The HOA has a duty to all residents to maintain safety and property values. The gate serves that purpose, but the plaintiffs never agreed to be part of the HOA, correct? Their properties predate the HOA formation?" "That's correct, Your Honor. But they're located within the boundaries of the HOA, and they benefit from the services the HOA provides." Judge Sinclair looked at the papers in front of her again. "Mr. Pemberton, I'm not seeing a legal basis for the HOA to restrict access to an easement that predates the HOA and contains no language allowing such restrictions. Unless you can point me to a specific statute or case that supports your position." Pemberton hesitated. "Your Honor, I believe the HOA's general authority to manage common areas provides that basis. But Mr. Kopecky has submitted evidence that the easement is not a common area. It's a private easement benefiting specific properties. Do you have contrary evidence?" "Not at this time, Your Honor, but we would argue that the public nature of the path makes it subject to HOA control." Judge Sinclair shook her head slightly. "I'm not persuaded by that argument. Based on the evidence presented, it appears the plaintiffs have a valid easement that the HOA is interfering with. I'm going to grant the preliminary injunction." I felt a wave of relief wash over me. Mike Torres, sitting next to me, let out a quiet yes under his breath. Judge Sinclair continued. "The defendant HOA is ordered to remove the gate and all other obstructions from the lake access path within 72 hours. The plaintiff's easement rights are to be fully restored. The HOA is enjoined from erecting any further barriers or imposing any fees or restrictions on the plaintiff's use of the easement. This order will remain in effect pending a final resolution of the case. Any violation of this order may result in contempt sanctions." "Is that clear, Mr. Pemberton?" Pemberton looked like he had swallowed something bitter. "Yes, Your Honor, good. I'm also setting this matter for a status conference in 60 days. By that time, I expect the parties to have either reached a settlement or be prepared to proceed to trial. We're adjourned." The bailiff called for everyone to rise as Judge Sinclair left the courtroom. The moment she was gone, I turned to Richard and shook his hand. "Thank you, that was perfect." Richard smiled. "She made the right call. Now let's see if they comply." Patricia and Pemberton left the courtroom without looking at us. I could see the anger in Patricia's body language, the stiff way she walked, the tight grip on her portfolio. I did not care. We had won, and she had 72 hours to remove that gate. The next day, I drove past the lake access path on my way to work. The gate was still there, Thursday morning, still there. I called Richard. "They haven't taken it down yet. They have until Saturday morning. If it's still up after that, we go back to the judge and ask for contempt sanctions." Friday evening, I drove by again. The gate was still locked, the sign still hanging. I took more pictures with my phone, documenting the continuing obstruction. Saturday morning at 8 o'clock, I went back. The gate was gone, not just unlocked, gone. The entire chain-link fence had been removed, the posts pulled up, the concrete footings jackhammered out. The path was clear from the road to the lake. Someone had even raked the gravel where the fence posts had been. I parked my truck and walked down the path to the water. It was late October, and the morning was cold, the lake calm and gray under an overcast sky. A few geese were paddling near the shore. The trees around the lake were mostly bare, their leaves gone for the season. I stood there for a few minutes, just looking at the water, feeling the satisfaction of having my rights restored. Over the next few weeks, things were quiet. I used the lake access several times, bringing my kayak down one weekend and fishing from the shore another day. Mike Torres was down there regularly with his boat. The other plaintiffs did the same. Life returned to normal. Then in early December, I got a letter from the HOA. It was not from Patricia this time. It was from someone named Sharon Hendricks, who identified herself as the new HOA president. The letter was brief and surprisingly cordial. It stated that the HOA board had changed leadership, that they acknowledged the court's ruling, and that they had no intention of further interfering with the easement. It also mentioned that Patricia Carmichael was no longer involved with the HOA. I called Richard and read him the letter. What do you think? Is this legitimate? I think Patricia probably got voted out after she lost in court. HOA politics can be vicious. This new president might actually be reasonable. But we're still going to proceed with the case to get a permanent injunction. I don't want them changing their minds 6 months from now. The status conference was scheduled for late January. A week before that, Richard got a call from Douglas Pemberton. Pemberton's firm was no longer representing the HOA. The new board had hired a different attorney, someone local named Beth Freeman. Beth called Richard and proposed a settlement. The terms were simple. The HOA would agree to a permanent injunction preventing them from interfering with our easement rights. They would pay our attorneys fees and costs, which by that point totaled just over $4,000. And they would record a formal acknowledgement with the county that the easement was private, not a common area, and not subject to HOA control. Richard walked me through the settlement agreement. This is everything we wanted. They're giving up completely. You get permanent protection, you get your money back, and it's over.
What about the other plaintiffs?
Same terms apply to all of you. Everyone gets their easement rights protected, and we split the attorney's fees proportionally based on everyone's share. I talked to Mike Torres and the others. We all agreed to accept the settlement. Richard prepared the final documents, and we signed them in mid-February. The case was dismissed with prejudice, meaning the HOA could never bring it up again. The permanent injunction was recorded with the county, becoming part of the public record attached to our properties. That should have been the end of it. But in March, I got an unexpected visit from Sharon Hendricks, the new HOA president. Unlike Patricia's visit, this one was genuinely friendly. Sharon was in her late 30s, a civil engineer who worked for a construction company in Grand Rapids. She apologized for everything that had happened and explained what had gone on behind the scenes. Patricia had been president for 3 years, Sharon told me over coffee at my kitchen table. She ran the HOA like her personal fiefdom. When she decided to put up that gate, she didn't consult the full board. She just did it, then told everyone it was approved. A lot of us didn't even know about your lawsuit until after you won in court. How did she get away with that? She was very controlling. Anyone who questioned her got bullied or frozen out. But when the legal bills started coming in, people started asking questions. We found out the HOA had spent over $12,000 fighting you, and we lost anyway. There was a special meeting in November. Patricia was removed as president, and the board voted to settle the case immediately. Where is she now? Sharon shook her head. She moved. Sold her house in January and left. I heard she bought a place in a different subdivision, somewhere near Rockford. I don't think she wanted to face everyone after what happened. I felt a grim satisfaction hearing that. Well, I appreciate you coming by to clear the air. It's the least I could do. The HOA is supposed to help the community, not create problems. What Patricia did was wrong, and I wanted you to know that not everyone supported it. Sharon finished her coffee and left. I sat at my kitchen table for a while afterward, thinking about everything that had happened. The whole situation had taken about 5 months from start to finish. It cost me time, stress, and money, even though I eventually got the attorney's fees back. But I had stood up for my rights, and I had won. The gate was gone, the easement was protected, and Patricia Carmichael had been forced out. Spring arrived, and with it came better weather. I spent a lot of time at the lake that year. I fished, I kayaked, I just sat by the water and enjoyed the peace. Mike Torres and I became better friends. We'd see each other down at the lake and end up talking for an hour about work, sports, or whatever was going on in the world. One Saturday in early May, almost exactly a year after the gate had first appeared, I was at the lake with Mike. We had both brought our kayaks, and we were getting ready to put them in the water. A guy I did not recognize walked down the path carrying a fishing rod. He was younger, maybe late 20s. "Excuse me," he said. "Is this a public access?" "No, it's private," I told him. "You have to own property in this section of Lakeshore Estates to use it. Do you live here?" "Yeah, I just bought a place on Willow Court, number 915. Is that in the right area?" Mike pulled out his phone and checked the plat map. "Yeah, you're good. Your property has easement rights to this path." The guy's face lit up. "Oh, awesome. I saw this on the map when I bought the place, but I wasn't sure if it was actually usable." "This is great. It's usable," I said. "Just make sure it stays that way. Don't let anyone tell you otherwise." "Will do, thanks." He walked down to the water and started setting up his gear. Mike looked at me and grinned. "You should tell him the story about the gate, maybe another time. Let him enjoy his fishing." But as I paddled out onto Lake Harmony that morning, I thought about how close I had come to losing all of this. If I had backed down, if I had agreed to Patricia's demands, the gate would still be there. I would be paying an annual fee for something I already owned, and every other property owner would be in the same situation. Patricia would still be HOA president, still throwing her weight around, still thinking she could override people's legal rights with a board vote and a padlock. Instead, she was gone, the gate was gone, and my access to the lake was permanently protected. The injunction was on file at the county courthouse. Any future HOA board would see it and know they could not touch the easement. I had not just won for myself, I had won for every property owner who came after me. The legal battle taught me something important. Standing up for your rights is not always easy. It costs money, it takes time. You deal with stress and anger and people who think they can bully you into submission. But sometimes fighting back is the only option. Sometimes you have to be willing to go to court to face down the people who are in the wrong and to make them back down. The following months were peaceful. Summer came, and the lake was busy with people swimming, fishing, and boating. I saw the new guy from Willow Court down at the water a few times. His name was Justin, and he had bought his place specifically because of the lake access. He told me the real estate agent had emphasized it as one of the key selling points. I did not tell him about the gate and the lawsuit until one evening in July when we were both packing up our gear at the same time. "You know," I said, "that lake access almost got locked up permanently." "What do you mean?" I told him the whole story. About Patricia Carmichael, the gate, the lawsuit, and the settlement. Justin listened with growing disbelief. "Are you serious? They tried to charge you for something that was already on your deed. $500 a year, plus restrictions on when and how I could use it." "What happened to President who did that?" "She got voted out and left town. Probably too embarrassed to stay." Justin shook his head. "Man, I'm glad you fought that. If you hadn't, I would have bought my place thinking I had lake access, and then found out I had to pay extra for it. That's exactly what would have happened. And the HOA would have kept pushing until someone pushed back." We talked for a while longer, then headed back to our cars. As I drove home that evening, I felt a deep sense of satisfaction. The fight had been worth it. Not just for me, but for everyone who would use that lake access in the years to come. In August, I got a letter from Beth Freeman, the HOA's new attorney. It was a courtesy notice informing me that the permanent injunction had been formally recorded with the county, and that the HOA had updated all their official documents to reflect the private nature of the easement. The letter also included an apology on behalf of the HOA board for the previous administration's actions. It was a nice gesture, and I appreciated it. I filed the letter with the rest of my property documents. The folder had gotten a lot thicker over the past year. It now included the original lawsuit, the court orders, the settlement agreement, and the recorded injunction. If anyone ever questioned my right to use that lake access, I had a paper trail that would shut down the argument immediately. The one-year anniversary of the preliminary injunction ruling came and went. I marked it by taking my kayak out on a perfect October morning, the air crisp and the leaves turning colors around the lake. I thought about everything that had happened, about the anger I had felt standing in front of that locked gate, about the satisfaction of hearing Judge Sinclair grant our motion, about the relief of seeing the gate torn down. In November, I ran into Sharon Hendricks at the grocery store in Cedar Springs. We chatted for a few minutes in the produce section. She told me the HOA was doing well under new leadership, that they had focused on reasonable improvements, like maintaining the common areas and organizing community events, and that there had been no more legal drama. We learned our lesson, Sharon said. The HOA exists to serve the community, not to control it. Patricia forgot that, and it cost everyone a lot of money and stress. I'm glad things are better now. Me too. And Trevor, I know I've said this before, but thank you for standing up to her. A lot of people were afraid to challenge Patricia. You showed everyone that she wasn't untouchable. I appreciated hearing that. It confirmed what I had believed all along, that fighting back had been the right choice. The holidays came and went. Winter settled in, and the lake froze over. I did not use the access as much during the cold months, but I drove past it regularly, and each time I saw that open path, I felt a quiet pride. That path represented something more than just access to water. It represented the principle that your rights matter, that they cannot be taken away by someone with a title and an agenda, and that sometimes you have to stand up and fight to protect what's yours. In February, I got a call from Richard Kopecki. He was not calling about the HOA case. That was long since closed. He was calling to tell me about another case he was working on, representing a homeowner in a different subdivision who was facing similar HOA overreach. The HOA in that case was trying to force the homeowner to remove a shed that was perfectly legal under zoning regulations, but violated some new HOA rule. I'm using your case as precedent, Richard told me. The principles are the same. The HOA is trying to enforce rules that conflict with existing property rights. Your case established that they can't do that. Happy to help however I can. You already helped by being willing to fight. A lot of people would have just paid the fee and moved on. You didn't, and now other people can benefit from that. That conversation stayed with me. I had not thought much about the broader implications of my case, but Richard was right. By standing up to Patricia and the HOA, I had created a legal precedent that could help other people in similar situations. That felt good. March brought warmer weather and the first signs of spring. The ice melted off the lake, and I started spending time down at the water again. Mike Torres was there too, working on his boat and getting it ready for the season. We talked about the upcoming summer, about fishing trips we wanted to take, about how good it felt to have unrestricted access to the lake. One afternoon in late March, a woman I did not recognize walked down the path to the lake. She was probably in her 50s, wearing hiking boots and carrying a camera. She took pictures of the lake, the trees, and the path itself. I was sitting on a folding chair near the water, so she approached me. "Excuse me, is it okay if I'm down here? I'm thinking about buying a property in this neighborhood, and my real estate agent told me about the lake access." "If you're buying a property with easement rights, then yes, you can use this path. Which property are you looking at?" "It's on Maple Drive, number 742. I was not sure if that address had easement rights, but I knew how to find out." "You should ask your agent to show you the property deed and the plat map. It'll say right there if you have access to this path. Make sure it's in writing before you buy." "That's good advice. Thank you." She took a few more pictures and then left. I sat there thinking about how that conversation would have gone differently if Patricia's gate was still up. The woman would have arrived to find a locked barrier and a sign threatening prosecution. She might have decided not to buy the property, or she might have been tricked into paying the HOA's fee thinking it was legitimate. Instead, because I had fought back, she could see the access clearly and make an informed decision. April brought rain and warmer temperatures. The trees budded, the grass turned green, and the lake came alive with activity. I was down there almost every weekend, sometimes fishing, sometimes just enjoying the outdoors. The lake access path saw steady use from the various property owners who had rights to it. It was exactly what it was supposed to be. A shared resource for the people who owned easement rights, open and accessible to all of them. In early May, almost exactly 2 years after the gate had first appeared, I got a piece of mail that surprised me. It was a newsletter from the Lakeshore Estates HOA. I usually threw HOA mail away since I was not a member, but something made me open this one. Inside was a letter from Sharon Hendricks and the current board, highlighting various community activities and improvements. At the bottom was a short paragraph that caught my attention. The HOA board would like to formally acknowledge the lake access easement holders and thank them for their patience during last year's legal dispute. We recognize that the easement is private property, not subject to HOA control, and we are committed to respecting the rights of all property owners in our community. It was a public acknowledgement printed in a newsletter that went to every household in the subdivision. Patricia had spent months trying to override my rights. Her successor was now publicly affirming them. The difference could not have been more stark. I kept that newsletter. It went into my property file along with everything else. Documentation mattered. If I ever sold my house, the next owner would inherit my easement rights, and they would also inherit the entire paper trail showing that those rights were protected and recognized. Summer arrived in full. June was hot and sunny, perfect weather for being on the water. I took my kayak out regularly, sometimes alone, sometimes with Mike Torres or other neighbors. The lake was busy but not crowded. People were respectful, cleaned up after themselves, and generally enjoyed the resource without abusing it. It was everything a shared easement should be. One Saturday in July, I was launching my kayak when I saw a for sale sign go up at one of the properties on Lakeshore Drive. It was 871, just a few houses down from mine. The owners, an older couple I had met a few times, were moving to Florida. I did not think much of it until a few weeks later when I saw people touring the property. The house sold quickly, and in August, new owners moved in. They were a young couple with 2 small kids. I introduced myself one afternoon when I saw them unpacking a moving truck. Their names were Brian and Holly, and they were excited about living so close to the lake. We specifically wanted a place with water access, Holly told me. Our kids love swimming, and we're planning to get a small boat. You made a good choice. The lake access is great, and the easement is fully protected. Brian looked curious. Protected how? I gave them the short version of the story about Patricia and the gate. Brian's eyes widened. Wow, so if you hadn't fought that, we might have been stuck paying fees to use the lake? Exactly, and the HOA could have kept raising those fees or adding more restrictions. We owe you a beer, man. Seriously. I laughed. Just enjoy the lake. That's payment enough. Over the following weeks, I saw Brian and Holly down at the lake regularly with their kids. The children were maybe 4 and 6 years old, splashing in the shallow water and building sandcastles on the small beach area. It reminded me why I had fought so hard. It was not just about me. It was about preserving access for everyone, including future owners and their families. September came, and with it the start of school and cooler weather. The lake was quieter, but I still went down regularly. Fishing was good in the fall, and I enjoyed the solitude of sitting by the water with a rod in my hand, watching the surface for signs of bass or pike. One afternoon in late September, I was fishing from the shore when a car pulled up and parked near the path. A man got out, looked around, and then walked down toward me. He was maybe 60, wearing khakis and a polo shirt. He had the look of someone official, maybe a government inspector or real estate appraiser. "Afternoon," he said as he approached. "Afternoon. Can I help you with something?" "I'm with the county surveyor's office. We're updating property records and I need to verify the easement boundaries here." "Are you one of the easement holders?" "I am. Trevor Brennan, 847 Lakeshore Drive." "Good. I've got the plat map here, but I wanted to see the actual site." "Do you know where the easement boundaries are?" I pointed out the 20-foot wide strip that ran from Lakeshore Drive down to the water. The surveyor took some measurements with a handheld GPS device and made notes on a tablet. "This matches what we have on file." There was some confusion in our records because of an HOA claim last year that this was a common area. We're correcting that now. There was a court case about that. The HOA lost, and there's a permanent injunction on file. "Yeah, I saw that in the records. That's why we're updating everything. We want to make sure the official maps are accurate." The surveyor finished his measurements and thanked me for my time. As he walked back to his car, I felt another wave of satisfaction. Even the county records were being corrected to reflect the reality of the easement. Patricia's attempt to take control of the path had not just failed. It had been erased from every level of the system. October brought the changing of leaves and cooler temperatures. The lake was beautiful in the fall, surrounded by trees in shades of red, orange, and gold. I spent several afternoons down there, just sitting and enjoying the view. It was hard to believe that 2 years earlier, I had been standing at a locked gate, furious and frustrated. Now I could come and go as I pleased, and my rights were protected permanently. In November, I ran into Mike Torres at a local hardware store. We had not seen each other much lately. He had been traveling for work. We caught up in the parking lot, and Mike mentioned that he had been talking to some of the other property owners about creating a voluntary association of easement holders. Not an HOA, he clarified, just an informal group that could coordinate maintenance of the path, maybe organize a cleanup day once a year, that kind of thing. Totally voluntary, no fees, no rules, just neighbors working together. That sounds reasonable. Count me in. Mike and a few others organized a meeting in early December at the Cedar Springs Library. About 8 of us showed up, representing different properties with easement rights. We talked about practical issues like keeping the path clear of debris, maintaining the gravel surface, and making sure people were being respectful of the resource. Everyone agreed to chip in for occasional maintenance, and we set up a simple email list for communication. It was exactly the kind of reasonable cooperation that should have been happening all along, without the heavy-handed control that Patricia had tried to impose. The year ended quietly. I spent Christmas with family in Lansing, and New Year's Eve at home. As 2027 began, I found myself reflecting on everything that had happened. The fight with the HOA felt like it belonged to another lifetime, even though it had only been 2 years. I had learned a lot from the experience. I had learned about property law, about the importance of documentation, and about the value of standing up for yourself when you're in the right. January brought snow and cold temperatures. The lake froze over again, and I did not use the access much during the winter months. But every time I drove past that open path, I felt a sense of ownership and pride. That path was mine, not because I had paid some HOA fee or agreed to their restrictions, but because I owned a legal right to it. That right was recorded, adjudicated, and permanently protected. No one could take it away. In February, I got an unexpected phone call from a man named Gary Sheffield. He identified himself as a property owner in a different subdivision in Grand Rapids, about 40 minutes away. He was facing an HOA dispute over a drainage easement, and his attorney had recommended he talk to me. "Mr. Brennan, I read about your case online. The court records are public, and my attorney thought it might be helpful if I heard directly from you about what happened." I spent about 30 minutes on the phone with Gary, telling him the story and giving him advice based on my experience. I emphasized the importance of having good documentation, hiring a competent attorney, and being willing to see the fight through to the end. "The HOA is going to try to intimidate you," I told him. "They're going to act like they have all the power and you have none. Don't believe it. If you have the law on your side, stick to your guns." Gary thanked me and said he felt more confident about moving forward. After we hung up, I sat there thinking about how far-reaching the impact of my case had been. It had started as a personal fight to protect my lake access. Now it was helping other people in similar situations. Spring came again, and with it the renewal of life around the lake. The ice melted, the trees budded, and the water came alive with fish and waterfowl. I was down at the lake access on one of the first warm days of March when I noticed something new. Someone had installed a small bench near the water, just a simple wooden seat with a brass plaque on the back. I walked over to read the plaque. "In appreciation of all who fought to keep this access open. May it remain so for generations to come." I did not know who had put the bench there, but it touched me. It was a quiet acknowledgement of what had happened, a recognition that the fight had mattered. I sat on the bench for a while, looking out at the lake, and felt a deep sense of peace. The months that followed were uneventful in the best possible way. I used the lake access regularly. I fished, I kayaked, I brought friends and family down to enjoy the water. The Voluntary Association of Easement Holders met a couple of times to organize maintenance, and everything worked smoothly. The HOA, under Sharon Hendricks's leadership, focused on legitimate community issues and stayed away from the easement entirely. In May, 3 years after the gate had first appeared, I took my kayak out on a perfect Saturday morning. The weather was ideal, the water was calm, and I had the lake almost to myself. As I paddled around, I thought about how different things could have been. If I had given in to Patricia's demands, if I had paid the fee and accepted the restrictions, the gate would probably still be there. Other property owners would be paying hundreds of dollars a year for something they already owned. Future buyers would be deceived into thinking the fees were legitimate. The HOA would have gotten away with taking something that did not belong to them. Instead, I had fought back. I had hired an attorney, gone to court, and won. The gate was gone, the easement was protected, and everyone who owned rights to the lake access could use it freely. It had cost me time and money and stress, but it had been worth every bit of it. As I paddled back to shore that morning, I saw Brian and Holly's kids playing in the water, supervised by their parents. They were laughing and splashing, completely unaware of the legal battle that had preserved their right to be there. That was exactly how it should be. They did not need to know the details. They just needed to enjoy the lake. I pulled my kayak onto the shore and secured it. Brian walked over and waved. "Beautiful morning, isn't it?" "Perfect," I said. "My kids love this place. We're down here almost every weekend in the summer." "Best decision we ever made, buying this house. I'm glad you're enjoying it." As I packed up my gear and walked back to my truck, I thought about all the people who would use that lake access in the years to come. Some of them would know the story of the gate and the lawsuit. Others would not. But all of them would benefit from the fact that someone had been willing to stand up and fight when it mattered. I drove home feeling satisfied and content. The fight with the HOA was over, and it had ended exactly the way it should have. My rights were protected, the access was open, and Patricia Carmichael was long gone. Justice had been served not through revenge or vindictiveness, but through the simple act of defending what was rightfully mine. The lake access remained open and unrestricted, a permanent easement serving the property owners who held rights to it. The locked gate that had once blocked my path was nothing more than a memory, a cautionary tale about what happens when someone tries to take away rights they have no authority to touch. My attorney had indeed unlocked it permanently, not with a key but with the force of law and the backing of a judge who understood what property rights meant. And every time I drove down to that lake, every time I launched my kayak or cast my fishing line, I knew that I had done the right thing. I had fought for my rights, and I had won. The gate was gone forever, and the path to the lake was open for everyone who had a legal right to use it. That was exactly how it should be, and exactly how it would remain.